Hello, I'm Justin M. Kennedy, an attorney with Little and Kennedy and Associates, a California estate planning and elder care law firm. Today, I'm going to discuss President Biden's proposed tax plan to establish a minimum tax on the wealthiest Americans. This proposed new tax law would target households with a net wealth over $100 million. It would impose a minimum effective income tax rate of 20%. But for this tax, the definition of income would include what we currently treat as income, as well as unrealized or unsold appreciation of capital gains. This means that if these Americans paid less than 20% in taxes based upon this new definition of income, they would owe additional taxes to bring their effective rate to 20%. Once paid, the tax will be treated as prepayments towards future capital gains tax liability, such as when the stock is eventually sold. To understand why people may be concerned about such a change to what is included as income, it may be helpful to review how current law works. Under current law, stock appreciation is not taxable until the stock is sold or there's a realization event. Once sold, you are taxed on the appreciation, calculated as the sale price less the cost basis. For example, imagine a long time ago you bought one share of stock for $100, and today that share of stock has increased to a value of $10,000. If you do not sell that stock, you are not taxed on that appreciation. However, if you do sell that stock for that $10,000, then the $9,900 of appreciation would be taxable gains. The triggering event would be the selling of the stock. Under this proposed law, merely having the stock appreciated in value would be treated as taxable income. This new tax would impose administrative challenges of valuing unsold assets. It is easy to value an asset when sold, as we use the sale value. But if it is not sold, what value should we use? For a stock traded on a stock exchange, it's relatively easy to determine the value of the stock on a certain day. But what if the stock was in a privately held company? Would the government require annual appraisals? That could quickly become very costly. Further, what if the individual was asset rich but cash poor? While we are talking about vastly different scales of assets and income, I have many clients who are worth millions of dollars, but the vast majority of that wealth is tied up in real property, leaving the clients cash poor. Now for the good news. First, this is not law. It is merely a proposal by President Biden. Second, even if enacted, the law is set to only target households with a net wealth over $100 million. Laws change over time, especially tax laws. And that is why it is so important to work with an experienced estate planning attorney who knows those tax laws and how the changes may impact you or your estate plan. Thank you.